counsels for Mr. Alexander Benedict Cummings, Senator Daniel Nitin, and Councillor Aloysius Tour. This afternoon, the lead counsel, Councillor Ibrahim B. Silas Sr., will offer the defense a statement on behalf of the defense and the defense counsel to the request for nolle prosequi from the state without prejudice. So at this time, I will invite Councillor Ibrahim B. Sila to the podium. Following his statement, we will take questions and answer. Thank you.
Thank you so much, Sadia. Good afternoon, ladies. I see one lady here, and gentlemen. This afternoon we have called on you all and want to thank you for responding to our call. You may have recalled that on January 3, 2022, the government of Liberia charged Mr. Cummings and two other persons with the commission of forgery and criminal conspiracy. On January 9, 2022, the trial commenced. The state commenced the production of evidence. On June 3, 2022, the state entered a plea of nolle prosequi without prejudice. That means the state pleaded with the court to terminate the case, but with reservation for the state to refile the case and or to arrest and try the defendants or prosecute them at any subsequent time if the state deems it necessary. We responded to that today at the court of the case and requested the court to grant the plea of nolle prosequi. However, we pleaded with the court to grant it with prejudice. That is to say, the state is not entitled to the reservation of any right to refile this action, to try or prosecute the defendants subsequently. Thankfully, the court agreed with us, and at 2 o'clock today, the court ruled, granted the plea of nolle prosequi with prejudice, meaning the matter is closed now and forever as it relates to the allegations contained in the complaint that was filed by the government of Liberia, even though the private prosecutor is the ALP. The basis for our resistance, in part, to request the court to deny the prosecution's request, in part, that is to say, to deny the request without prejudice and to grant it with prejudice, is that when the prosecution of a case commences, the defendants are arraigned, meaning that they appear in the answer to the charge. The state begin to produce evidence, except for events of manifest necessity. If the trial is terminated at the instance of the prosecution, double jeopardy attaches. In the instant case, there is no such situation, no event of manifest necessity. Manifest necessity could be the illness of the judge that made it impracticable for us to continue. Anything that is beyond the control of the court that makes it impracticable to continue the prosecution of the matter will be manifest necessity, meaning it is not at the instance of either the parties nor the court. In this case, the prosecution, the state, decided voluntarily to terminate the matter after it had produced evidence. Therefore, double jeopardy will attach for any subsequent prosecution. As I indicated, thankfully, yes, the court granted the nolle prosequi plea with prejudice. The state announced an appeal we see as awarded will perfect their appeal. Interestingly, you will note that the government entered the plea of nolle prosequi immediately after the Supreme Court handed down its opinion in a matter involving the ALP, the Unity Party versus the CPP, concerning the National Elections Commission decision that was taken to the Supreme Court. And we found that very interesting. Subsequently, the Solicitor General Counsel Samuel Cephas issued a release to the effect that the Supreme Court decision made it impracticable for him to continue or for the government to continue the prosecution of this matter. And he tried to give the public the impression that is as a consequence of the Supreme Court decision that they were constrained to enter a plea of nolle prosequi. We found that quite interesting, and I want to say categorically here that Counsel Cephas misled the public. He is dead wrong in his analysis of a release of June 3, 2022, relying on the Supreme Court opinion as a basis for them to terminate the matter. We strongly believe that Counsel Cephas and all of the co-conspirators against Mr. Cummings and others knew and do know within themselves that the evidence does not exist. It did not exist and it does not exist. And so they were finding it all the more difficult to proceed with the prosecution. All they intended to do a well-planned, calculated attempt to defame Mr. Cummings, to narrow his chances in the political space, and to categorize him as one of them. Unfortunately, they knew very well that Mr. Cummings was being adequately, and others were being adequately represented. And so as such, it made it all the more difficult for them to have gone any further. We knew that our evidence would have shown, number one, that the CPP framework document, as reviewed by the lawyers, was submitted to the parties, it was reviewed by the parties, it was accepted by the parties. The evidence would have also shown that the controversial clause 8.5 subsection 2 on withdrawal, the exit provision, was incited when the lawyers did a review. It was discussed with the parties at the Liberty Party headquarters. But it was a whole design on the part of 3 of the parties. So the exit provision was targeting Mr. Cummings to make it practically impossible for him to leave the CPP. Now that it caught up with them, they thought the only way out was to malign his character, defame his character. This is exactly the situation we have today. But the evidence would have shown that that controversial clause was placed in there by the lawyers. And the lawyers are here in this country with flesh and blood. They would have come to testify to the effect that they introduced it, they incited it there. And the parties accepted it. They thought that it would have been a booby trap for Mr. Cummings. It turned out to be a booby trap for themselves. So the Supreme Court opinion absolutely mentioned nothing about the criminal trial. And the court could not have done so because the court could not have commented on an ongoing matter in the lower court. The court could not have done so. If you have read the Supreme Court opinion, it says nothing about it. So for the Solicitor General to give the public the impression that the state was constrained to enter the plea of nolle prosequi because of the Supreme Court opinion, that is totally misguided, unfounded, and with all an iota of truth. We want the public to get this clear. The only reason why they were constrained to enter the plea of nolle prosequi because they know within themselves that the evidence does not exist. It has never existed. And they knew at the end of the day, the truth would have been uncovered. And so a way to do it is to delay the trial. Thankfully, a matter went up to the Supreme Court, to delay the trial and wait for the Supreme Court to make a decision and use that as a pretext to terminate the matter. We want to say, thank God he's alive. We want to say thanks to the judge who conducted the trial in the most transparent and impartial manner, and who has the spine today to deny the prosecution's request for a plea of nolle prosequi without prejudice, and to grant our resistance that it be granted with prejudice. You have a copy of the ruling. You can read it. So we want to say many thanks to any one of you. If you have any specific question, we are open to respond to those questions. Thank you so much.
Yeah.
Yes, sir.
My name is Inas Mova. I work for ABC Radio. Honorable Cummings went through 6 months of trial. He suffered pain, anguish, agony. Just to refresh your memory on some of the things he suffered. He sat on the prisoner bench. He knew about from that the defendants or criminals knew, alleged criminals, you have remedy under the law to countersue the government for defamation of character and the pain your client suffer. Are you contemplating on that?
Well, that is a decision for Mr. Cummings himself to make. He is a client. We act on his instruction. So I will ask that you refer that question to Mr. Cummings, because he makes that ultimate decision as to whether he wants to sue in damages for the pain and agony that he suffered. I do agree, he did suffer pain and agony. No man who has built his reputation up to this point will want his hard-earned reputation to be tarnished in the manner and form in which it is done. I'm not too sure that it will be wise to institute an action against the government, but an action can be instituted against those who made the allegations against him, those who accuse him. The Benin Ayure, the Tudor Mobile, yes, he has a remedy, but he has to make that ultimate decision. Yes.
Did the report by Mrs. Blair in the Omnia Alaco arrangement, did that have any bearing on the court's decision?
Certainly so. It has not the court decision, but it has a bearing on the prosecution's plea of not a prosecutor. Because that report is so detailed, it speaks to all of the transactions, the interactions that went on, most especially in the CPP NDC chat room. The approvals were done in the chat room. Because of COVID-19, those chat rooms, 2 chat rooms were created, one by Ben Lure, one by Mr. Cummings. The one created by Mr. Cummings was used by the parties. It was an official form, medium of communication by CPP members. So the framework document that was reviewed by the lawyers, January 25, Mr. Cummings submitted it to them. Sorry, that July 25, 2020. Mr. Cummings submitted it to them. Made follow-ups. There was Zoom meetings. That Theodore Mogo sat in the Zoom meeting and said, we have no further comments. Mr. Cummings sent back to them to say, this is a chance for you to make your changes to the document and send your approval by your resolutions. The resolutions for the parties were followed subsequently. So the report is so detailed. So I want to strongly believe that knowing fully where the evidence did not exist, coupled with the fact that the report came out and exposed all of those errors, even challenging the CPP own investigative report, because that report is very limited. It did not consider all the transactions in the chat room, and I know that was intentional. So I agree with you, yes, it made a very good impact in the state's application for the plea of no prosecutor.
But I mean, was it admitted to court as evidence?
No, it was not admitted because we would have made that determination to have it admitted into evidence, and possibly to have the leader come or any of our team who work on the document to come and testify. We would have made that determination. But because we did not produce evidence, the state was producing evidence and decided to terminate the trial. The way the trial works, the state will produce the evidence, that will complete and the rest. And then the defense will now begin to produce evidence. So we did not reach at the point where the defense should have produced evidence. It's the state in the process of producing their witnesses. I think it was the 6th witness that was on the stand. He was on the cross-examination, and they just terminated the matter by filing a plea of no prosecution.
My name is Gerald, calling in Front Page Africa. So after all has been said and done at the end of the day, what do you make of the way the case ended? That the request to cancel and the request that was granted by the judge to cancel the case with prejudice. What do you make of it? Is it a victory for you?
Well, it's a victory, but I would have loved this matter to have ended in a way that Mr. Cummings would have had the opportunity to present his side of the story to the Liberian people. That would have given the Liberian people a better picture, a full appreciation of the both sides. As it is, the public only listened or had the opportunity to listen to the witnesses of the state, most of whom, including Ambassador Joseph Yuma Boakai, were incorrect. They were totally incorrect. They told stories that totally outside of the ordinary facts of the case. So I would have loved the opportunity for Mr. Cummings himself, along with the other witnesses, but the defense will have the opportunity to produce the evidence so that the general public would have a full appreciation of the both sides of the story. However, what we wanted is the restoration of the liberty of the defendants. Now that their liberties have been restored by the court, we are very happy. We think it's a victory.
Did you just mention that many of the witnesses didn't tell the truth? Did you say that includes Ambassador Walker?
Certainly so.
But you haven't had a chance to cross-examine any of the witnesses.
I did cross-examine them. That's how I'm able to determine that what they said was totally incorrect. That's how I got to know, because I have reviewed the facts. I have reviewed the voluminous,
You cross-examine him in court?
Exactly so. We did. So on the basis of that, we see the inconsistency between the testimony of Ambassador Boka and the testimony of Chodo Mumu. If you look at the two testimonies, you will know that Ambassador Boka, notwithstanding his total lack of knowledge of most of the transactions that went on, he gave the public the impression that he was informed.
My name is Jonathan Brown from the New Dawn. Though he said that it's Mr. Kuma's decision to file for defamation if he so desires. But in your opinion, it will not be a wise decision. What do you mean?
No, I didn't say it will not be a wise decision. I said filing it against the government.
Yeah.
All right? Against the government. There is a principle called qualified immunity. So under that principle, you cannot you cannot sue or prosecute the state for bringing charges against you. All right? Except you can prove that it was done on the basis of persecution and not prosecution. Forced imprisonment. Okay, those are principles under which you can go. But those who wrote and made the allegation against the individual people, who are the private prosecutors, yes, you have a right of action against them in a civil proceeding. To make that decision is for Mr. Cummings. We cannot make that decision.
Do you think there's a case for that now?
Whether Mr. Cummings has a right to?
I have a case. Do you think there's a case for that now in terms of, based on what has transpired so far, is there a sufficient argument that you can build to present a case for damages?
Sure. We think there is sufficient basis for that. Yes. Yes, sir.
Yeah, okay. I'm Sheikh from the Capital Newspaper. So the resolution of the case from the court means that the CPP stands at a position that either it is being dissolved or it is at the trend of dissolving. And Mr. Cummings always used to be called the presumptive CPP leader. Is there any future for the CPP now that the case has been dropped? Or?
Well, I wouldn't speak for the CPP because we are not representing the CPP and we are not the lawyers for the CPP. We are strictly the lawyers for Mr. Cummings and the other two defendants. So as it relates to anything surrounding the CPP, I prefer not to speak on it, please.
Okay, my cousin, the other from the Heritage. You accepted the Honorable Waka, his medical testimony did not tell the truth. So what do you think warranted his stand?
Well, look, let me tell you one thing. There is one objective that the state was able to achieve. And that objective was to disintegrate the CPP. To put leaders of the CPP against themselves, to the effect that there will be no reconciliation. So the effect of Boaka coming to testify was to only put Boaka against Cummings. The effect of bringing possibly Euro to testify would have been to put Euro against Cummings, to disintegrate the CPP, make sure they do not hold and they do not and there is no reconciliation. That was the only objective that was being achieved.
Yeah, yes. My name is Mike Abraham, and I report for Sky. Having reached this stage in this case,
You as legal counsel, what do you hope to achieve to see from the legal team of Reverend Cummings?
Well, I think we've done a perfect job, and I want to congratulate my colleagues on Attorney Sedia, William Wallow, or Attorney Orishobu, and the entire HPA team. I think we've done an excellent job. We were in the front line, but the research team was always busy doing the work. So we expect that there will be lessons learned by the opposition, there will be lessons learned by the government itself, that you should not indict before you go search for the evidence. The indictment must be based on the evidence. What we have seen in this case is there was no investigation done by any law enforcement agency. I agree that is not a prerequisite for prosecution, but that will inform you, that will give you the basis. That's one. Two, the evidence were glaring. You recall at a certain point in time, we even brought to the court's attention that there were intentional omission of exculpatory evidence by the prosecution. That was prosecutorial misconduct. And they admitted to that in the court. All right? So these are lessons learned. We live in a country where we say, yes, we are a democratic state, so we should ascribe to the tenets of democracy. Prosecute only when the evidence exists. If the evidence does not exist, you are not. That would be totally persecution. And our team, Mr. Cummings, was being persecuted.
Yeah, Mr. Claire.
We'll entertain two last questions, if that's okay. So we'll do 1 and 2.
Yes.
Yes.
Mr. Towa, Alfonso. You mentioned that the state achieved something. What I wanted to achieve was to disintegrate CPP. But, Council, I think the issue at stake was instituted by Mr. Yuri. So why would you say that the state achieved this? That's one question. Two, the exit clause, which you mentioned about, will you say that, because you said people thought it was like a booby trap for Mr. Cummings. So one way or other, will you make or say that it helped Mr. Cummings in that way?
Well, let me take the first one. The first one, why it is true that the criminal action, the complaint, it's a private prosecutor who took the complaint to the government only needed the opportunity to explore. They needed that opportunity. It's like someone who has a criminal mind. What he looks for is the least opportunity to commit the crime, right? So the government wanted an opportunity, and the opposition lent themselves to that opportunity. So the government exploited it sufficiently. The second point with respect to the exit clause, I do not think it benefited Mr. Cummings in any way, neither has it benefited any of the parties. It was intended to make sure, from my interaction with the lawyers who reviewed the document, it was intended to make sure that the opposition remained together. Because in their experience, opposition parties get together in coalition. By the time you get towards the elections, there is disintegration. So all the thought, and you have some of the best legal minds, people of wealth of experience who were involved in the process. Councilor Benedict Sano, Justice Johnny, all right? They were involved with the process. So the intent was to have it in a way that they remain cohesive. If you are in it, you remain in it, and you don't get out. That was the intention. So it was intended to help everybody, every one of them, and it was intended to make sure that there is cohesion. But I think others tried to exploit it because they felt that going to primary would have been all the more difficult for them to succeed. And so that was the best way they could get out of it. But I think they destroyed themselves to a large extent. Yeah.
Yes, I'm not going my opponent on the district.
Okay.
You discuss about the rules of the lawyers are reviewed.
Yeah.
During the course of the trial, do you anticipate a time to invite them as part of the procedure for the South Commission to address this?
Absolutely correct. We would have done so. We have interviewed them. They were prepared to appear and to testify. And that's the more reason we say this is what our evidence would have shown to the Liberian people. And the prosecution, the government knew that very well. That had we gone to the end of the trial where the defense would have had the opportunity to produce evidence, the defendant's style of the story would have been different. And so in order not to give Mr. Cummings and others that opportunity, they sought to exercise their right to terminate the trial. Because the way our system works is that the prosecution is done by the government. The government can decide to prosecute and decide not to prosecute. If they decide, if the government commence prosecution and decide to terminate that prosecution, you cannot force them. So you must prosecute me. No. If we had that opportunity, we would have insisted to say, no, let's continue with this trial. But that's the law. When they entered the order prosecutor, all we had to do is say, do not grant in the request without prejudice. Grant it with prejudice to them, so it means that the matter is closed now and forever. They don't have the right to re-litigate it. Thankfully, the judge granted it. So let me say thank you ever so much for coming, and God bless you.